This case is as tragic as it is sobering. At the center of today's hearing stands 6-year-old Marlon Daniels, charged with 2 counts of intoxication manslaughter, a second-degree felony in Texas that carries up to 20 years in prison per count. The victims? A young mother and her 5-year-old son struck and killed while walking on a quiet San Antonio sidewalk. As the judge lays out the plea agreement, 18 years behind bars, a $2,000 fine, and an affirmative finding of a deadly weapon, you can feel the gravity in the room. This isn't just another DUI case. This is about accountability, remorse, and the irreversible damage caused by a single decision to drive drunk. And here's the twist: despite the agreed sentence, the defense is pushing for a pre-sentence investigation report, or PSI, something rarely requested when prison time has already been settled. Why? To ensure the Texas Department of Criminal Justice fully understands Daniels' background, his military history, mental health, and addiction struggles before he begins his sentence. Question for you: should the system still prioritize rehabilitation for offenders who cause such devastating loss, or should justice focus purely on punishment? Stay tuned. The judge's reasoning behind this PSI request is about to spark a powerful back and forth that reveals how even clear-cut cases can have layers of legal complexity.
And the court will recommend the therapeutic community. There's something you wish to say, counsel?
Yes, on the PSI, it said that he had the
All
combat.
right, is there anything else?
Risen. That's all we have.
All right, Mr.
All right,
Daniels,
so
everyone, just give us a moment. We're going to have medical check him out to see what's going on. And then if you will be patient, we'll have him brought back out if they say that he can be brought back out. So what's going on? 09218, State versus Marlon Daniels. Can I have parties announced for the record?
Megan Galloway for the state.
George Sharman on behalf of the defendant.
In each cause, you're charged with intoxication manslaughter. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
And each of the cause numbers, according to the plea bargain agreement, punishment is to be assessed at 18 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. There are no applications, and the cases will run concurrently. And there's $60 restitution to DPS. Did you understand that to be your plea in each of the cause numbers?
Yes, ma'am.
Then to count 1 in cause number 2024 CR 009218, how do you plea?
Guilty.
To count 1 in cause number 2024 CR 009219, how do you plea?
Guilty.
State in each of those cause numbers, is there any evidence to support the defendant's plea?
Yes, Your Honor. The state offers states 1 and attachments in each cause.
Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty in each cause number. Are we proceeding with sentencing?
I've requested a PSI on the case.
All right, what's the purpose?
I gave it to you last week.
No, I mean, what's the purpose of the PSI?
Well,
Do you not want me to follow the plea?
no, the purpose of it is for you to see the things that he's going to be doing. And it also helps to determine his, I guess, incarceration, what's going to happen to him there. And it gives them a basis of information about the case and about him.
But when he is incarcerated, they will do their process to see what would be appropriate, what treatment is appropriate for him.
I understand, but they have more things that they can do here to provide that information to the prison. And it's also a mandatory right that he has to have.
I mean, if you want a PSI, of course, I will give you a PSI. I just don't understand the purpose of the PSI when you both have agreed that he's to serve time in custody.
Yes, and if you read the case law that I
No, I'm telling you, I understand that you're entitled to a PSI.
Yes.
I just don't understand the reason for it. I could see if I'm requesting a PSI because I've read the facts and maybe I'm not going to follow your plea bargain agreement, but he's agreed to prison time. I don't understand the need for a PSI. That's what I'm just trying to understand.
Right. And the point is that here locally, when they do the PSI, they have more information than the prison will have on his background, his military, everything that he's doing in the community here in his education. They will have more information to take with him to the prison. They will not have the ability to do the things that they can do here.
All right. It's the court's understanding that they do have the ability to do that. However, you want a PSI, the court will give you a PSI. Ms. Abrams, see if they can expedite the PSI. And I will give you a date. You're going to be taken into custody today. And let me call and see if I can get a date. All right. Is there anything else?
That's all we have.
All right. Thank you. Yes.
We did have family here for victim impact statements because it is an agreement. Is there any way that he can be sentenced and then just have the PSI done?
No, once a PSI is requested, the court has to have it beforehand. If they want to give victim impact statement by Zoom, they're welcome to do that. If there's no objection, I'll see if I can call probation and get this expedited.
Okay.
Fine.
24 CR 009218 and 2024 009219. State versus Marlon Daniels. Can I have parties announced for the record
Megan Galloway for the state.
and for the defense?
George Sharman on behalf of the defendant in these cases.
All right, and you're Mr. Daniels?
Yes, ma'am.
All right. Mr. Daniels, the court, at the request of your attorney, had a PSI ordered. And Mr. Daniels, we're going to proceed with sentencing. And each of the cause numbers, you entered a plea of guilty, and the punishment is to be assessed at 18 years in the prison. Mr. Daniels, I've had a chance to learn more about your background from your attorney, your military service. And I will tell you, I know that no one, at least I have yet to have someone come before me and say my intention was to get drunk and go out and hit somebody, or get drunk and drive drunk. Nobody ever intends to drive intoxicated or get to that point, but it happens. And that's why I always try to stress to everybody, please, please, if you're going to be drinking at all, even if you think it's just going to be one drink, it's better just to have a designated driver, right? Okay. And I do appreciate the fact that you entered a plea, that you accepted responsibility by pleading guilty, and that you have not wavered and try to blame something else for this. I do note that you said that you couldn't remember, but you know it's true, and I appreciate that. Sometimes people will say, well, I don't remember what happened, so I'm really not responsible. But you didn't do that. And the fact that you entered a plea, and in each of these cause numbers, you were looking at 20 years. And I always tell people, when people go to jury trial, even when I was a defense attorney or as a prosecutor, I sometimes would have to explain to families, you don't know what 12 people are going to do, right? When you go to jury trial, you don't know. 12 people could say, you know what? This person before me is a military veteran. This person before me hasn't been in trouble. Yes, they did this, but we're not going to give them 18 years. Who knows? A jury may decide to have given you 2 years or 3 or 4 or whatever. You just never know. So for you to accept responsibility, for you to take the 18 years, knowing that by taking these 18 years, there is no appeal because you waived your right to appeal. I think that says a lot, even though I know that the family is in a lot of pain, because when you lose someone and you lose someone this way, it's not expected. So the court is recognizing that you entered pleas of guilty to each cause number. that you accepted responsibility and you took close to the maximum sentence in each of the cause numbers. With that being said, and cause number 2024 CR 009218, the court will follow your plea bargain agreement as previously stated. When you entered your plea, the court is finding you guilty. The court will sentence you to 18 years in the prison. There's a $2,000 fine. The court will give you credit for any time served, and legally, you're entitled to any time that you have served on this case. This will run concurrent with 2024 CR 009219. I'll request the therapeutic community. The therapeutic community doesn't increase the time that you're in custody. It's merely designed to help you maintain your sobriety, address any type of mental health or substance abuse issues you may have, so that ultimately when you're released from prison, you will maintain your sobriety. And there's an affirmative finding of a deadly weapon.
May I address the court on the matter?
Just one moment.
Yes.
And cause number 2024 CR 009219, the court is finding you guilty. The court will sentence you to 18 years in the prison, give you credit for any time served. There's an affirmative finding of a deadly weapon. This will run concurrent with 2024 CR 009218. There's to be restitution of $60 to DPS for testing. And the court will recommend the therapeutic community. There's something you wish to say, counsel?
Yes, on the PSI, it said that he had the combat risen. He did not have combat treatment. So that was erroneous.
Okay.
Step number 2, it shows there were 2 priors of misdemeanors. There was only 1. And if you look at it, it's the same date on each.
Okay. All right. Is there anything else?
That's all we have.
All right, Mr. Daniels. Deputy Laura, if you'll give him his trial court certification.
Correct.
All right. Counsel? Counsel.
Yes.
All right, your client has been removed from the courtroom. Did you review the trial court certification of defendant's rights to appeal with him?
I did.
All right. On the record, the court informed the defendant that by entering the plea, he had waived his right to appeal, so he acknowledged that. I followed the plea bargain agreement. So because I followed his plea bargain agreement and because he's waived his right to appeal, he do not have the court's permission to appeal.
I went over that with him, Judge, so he understands.
All right. Thank you. All right. So everyone, just give us a moment. We're going to have medical check him out to see what's going on. And then if you will be patient, we'll have him brought back out if they say that he can be brought back out. And then you can give your victim impact. So what's going on? Okay.
And we start with new details this noon. A woman and her child hit by and killed by a driver while walking on the north side.
Now we know their identities, and police arrested a driver. San Antonio police accuse 56-year-old Marlon Daniels of crashing his car into 39-year-old Vanessa Ramos and 5-year-old Solomon Lopez last night. This was on Stone Oak Parkway, not too far from Highway 281 on the far north side. The mother and daughter were on a sidewalk. That's when police say a driver jumped the curb and crashed into a utility pole.
Police tell us that the driver continued down the sidewalk and struck the mother and daughter. Officers accused Daniels of driving fast before the crash and was found to.
With the final gavel strike, Judge Boyd delivers a clear message. Even in tragedy, accountability must come with humanity. Marlon Daniels will serve 18 years in prison for taking 2 innocent lives, a mother and her child, after driving intoxicated. Despite moments of confusion over the PSI report, the court ultimately ensures that Daniels' record, background, and mental health history are fully documented before incarceration. But this sentencing goes beyond one man's punishment. It's a warning to every driver who thinks just one drink is harmless. In Texas, intoxication manslaughter isn't just a traffic offense, it's a deadly crime that shatters families forever. And perhaps the most haunting part? Daniels never meant to kill anyone. Like the judge said, no one plans to get drunk and take a life, but it happens when choices turn fatal. What do you think? Does 18 years seem fair, or should the law come down even harder in cases like this? Drop your thoughts in the comments. If you found this breakdown eye-opening, hit that like button, share this video to spread awareness, and subscribe to Courtroom Chronicles for more real courtroom footage, expert insight, and raw moments of justice you won't find anywhere else.